Divorce and bankruptcy. I couldn't pick two more interesting subjects, right? But it's important because you have to understand how bankruptcy could affect a divorce and vice versa. Today, we're going to focus on how bankruptcy could actually affect a divorce and the way that assets are going to be distributed. Now, I see a lot of confusion, and usually the confusion is because we're dealing with two different areas of law, right? We're dealing with state law and federal law, and you have to understand that that's part of what creates this confusion on how these issues are handled. So the best way to explain it is, and I did write a blog post on this issue, as you can see here on the screen, regarding the Second Amendment and how bankruptcy, even though you have a right to bear arms, bankruptcy, your guns are worth something. They have some sort of value, and so they may not be protected in bankruptcy. Again, every state is different. Always look up the exemptions in your state. Remember, exemptions are what protects your assets when you're filing for bankruptcy. But I think the idea of firearms is a perfect example. So we'll start with federal law. Federal law says you have the right to have a firearm. There's no state that says you cannot. There are restrictions, right? Not every single state allows you to walk into certain areas. Some of them you might have to have a license. So if you're a convicted felon, you can't carry a firearm. But you see how the state cannot pass a law that says you can't have firearms. It's just not allowed. And again, the reason why is simple. Federal law. When you think of the U.S. Supreme Court, think about what it says here, supreme. That is why the federal law is considered the supreme law of the land. See how that ties into the U.S. Supreme Court? So that's important to know because you're going to have state law, you're going to have federal law, and there could be a conflict between both where that's where people get confused and don't understand how one thing could affect could affect another. But that's the way I look at it. The state cannot pass a law that will conflict with federal law. So that's the important part to keep in mind. Now, with bankruptcy, we have to worry about issues with the car, right? And there's plenty of blog posts that I have on what happens with your car. When you file for bankruptcy, is it protected, not protected, negative equity? All that is discussed in all these other prior blogs and videos. But let's get down to the facts. When you get divorced, let's assume there was no trial and the results wouldn't matter. Let's just say at the end of the day there's an agreement, and part of that agreement says you are solely responsible for your car. Perfect. Your spouse is solely responsible for their car. Perfect. Who's on the loan? Because that will affect ultimately bankruptcy, your credit report, and everything else. Now let's try to figure out why. The real reason is simple. It's contract law. Contract law is what basically started this whole process, right? You went to go apply for a car. When you applied for the car, maybe the dealership says you must include your spouse on the car loan. So now your spouse has been added to the car loan. Contract law is simple. You're both liable for the car. What the judge says is not going to change that original contract. That was a contract that was entered into before you went into divorce court, before the judge ruled. The judge cannot undo that. But unfortunately, you see all the time where people say, but my marital settlement agreement says the other spouse is solely responsible. They are, according to contract law. Federal law is going to be a little different. You're going to see how that's going to affect it. Now, if everybody's on their own loan, then it doesn't really matter, right? Because if the car is in your name and the car that your spouse is driving at divorce is in your name, then none of this really matters. The issue is when you're both on the same loan. And so now you have this marital settlement agreement that has been approved by the court, and the judge says you are solely responsible. What if your spouse goes through some hard times and has to file for bankruptcy? You're both on that loan. Does that change anything? Absolutely, because again, it goes back to contract law. You both agreed to be responsible for that loan. And so while I might say in a marital settlement agreement that one party is solely responsible, what does that really mean? Really depends on the situation. Let's jump first into bankruptcy. If your spouse is files for bankruptcy and you both share that, both of your names on that car loan, legally, that's no longer your spouse's obligation. Bankruptcy, remember, bankruptcy is up here. Federal law is up here. State law is here. Federal law will trump state law every single time. So will this affect your credit? Yes, because you are on the loan. And so that's one reason why I always tell clients, let's try to refinance. Let's take a hit financially, maybe sell the car, lose some money, but at least you don't have to worry about this, especially with a mortgage. A mortgage sticks around for 20, 30 years. So imagine for 20 years there's problems with the mortgage, late payments throughout those 20 years. That's affecting your credit if you're on the mortgage. That's why I always recommend for clients to refinance to avoid this issue. So now you have your spouse, your ex-spouse, who went and filed for bankruptcy. Federal court says your spouse is no longer responsible for that debt. What's going to happen with that debt? Well, very simple. Let's go back over here. Contract loan. There's two people on this loan. One person is gone. They already filed for bankruptcy. That leaves you. You are now responsible for that loan. I know. It says you're not responsible. The judge says you're solely responsible. But here's the catch. With bankruptcy, forget it. There's nothing a state court judge can do once a party has filed for bankruptcy on a personal property issue like this. But let's say your spouse doesn't file for bankruptcy, but is paying late, gets sued by a creditor, decides not to still file for bankruptcy. The creditor is still going to sue both of you. How does this protect you? Well, you could always go back to family court and say, I got sued by the creditor. They took out $2,000 from my bank account. Supposedly, my ex spouse was solely responsible for that vehicle. I need to get paid back those $2,000. You'll get it. You'll get the court order where the judge says your ex spouse owes you $2,000. Listen to what I said. Court order saying your ex spouse owes you the money. If your ex spouse doesn't have the money, then all you have is a piece of paper that says they owe you the money. Maybe things change in the future. Maybe more income comes in from your spouse or other assets, and then you can pursue it at that point. But basically, if your spouse is this close to filing for bankruptcy, that piece of paper is not worth much. We have an old saying, the piece of paper is worth more than what's written on it. Because at the end of the day, if you can't collect, if you're judgment proof, meaning there's no way to collect on the debt, then that piece of paper doesn't mean much at the end of the day. So you got to keep in mind, that's why I always tell clients, let's try to refinance. The car's upside down. Let's try to figure this out. Or try to have your spouse refinance once a year. Hopefully they can get approved for a loan to get this off your credit report. Because if your spouse starts making late payments on a loan that you are both on, regardless of what that divorce agreement says, if you're both on that loan, at the end of the day, it's going to affect your credit. So everything is good until all of a sudden you need a loan or you're applying for a mortgage and you pull your credit and then you find out your spouse sporadically pays the car loan in order to not get it repossessed, falls behind 1 or 2 months, catches up, falls behind 1 or 2 months, and this process has been going on for 1 year or two. You're not going to get that loan. You could always, the credit reporting bureaus will allow you to make a statement. But for something as complicated and as expensive as a loan, where all the paperwork, all the details, everything has to be perfect, there's a good chance that creditor is going to say no, unless, right, your deposit is much bigger, your interest rate might be higher, and now you're losing money again. And so it doesn't, it's a lose-lose situation. So again, we can't predict what's going to happen in the future. That's why I say let's try to get out of this now. Let's try to refinance that car. Let's try to continue to refinance. If it's a mortgage, my answer is the same. Let's see if we can continue to try to refinance that mortgage to get your name off the mortgage. If not, you're going to be responsible, even though you have here, the judge says the other party is solely responsible. Once they file for bankruptcy, that doesn't matter. At the end of the day, that debt becomes yours. And now you see why you have to try to split away from all the debts and all the assets to make sure that whatever happens, you're the only one on that loan, or your ex-spouse is the only one on that loan, so it never comes back to haunt you. Okay? So if you have any questions, today was a brief video, right? Second video in the day, so I am pushing forward. Reach out to me. Send me an email. If I accept your question, I'll put it in the reader's question forum as a blog so you can read it, and so can everyone else. Of course, I'll make a video out of it too. Of course, we always will remain anonymous. I'm not going to reveal any information. But, if you need to reach out to me, there's a quick and easy way to do so. If you're my paralegal students, legal study students, paralegals looking to learn more, like always, I've mentioned before, there's my textbook. It's published by Routledge Publishing. You have plenty of information there on all the different steps you need to file for bankruptcy. And of course, come find me on social media. Let's talk via Facebook. Let's talk via Twitter. Let's have conversations back and forth. Just come by and say, have a good weekend, right? I'll tell you the same thing. Have a good weekend. It's 5 o'clock somewhere, right? Now, to close, remember what I said before I sign off on you. Just because a debt says you're solely responsible for that debt, understand that contract law makes it clear who is really responsible for that debt. And don't put yourself in a position where if your ex-spouse is going to be paying late, this is going to affect you, especially, once divorce comes through, that is one of the top three reasons people file for bankruptcy. And you're trying to get back on track financially, you're working hard to improve your credit, and then something like this comes along that messes up your credit and blows any shot you have at, getting a new car or getting a mortgage. Even worse, what if you're trying to just get an apartment lease and the landlord says, not with all those late payments on the car that you've made over the last, 15 months, and you're thinking, I haven't made any payments on that. That's my ex-spouse's car. Doesn't matter. All right. So take care. I will see you at the next video. Come check out the blog so you can see all the other issues that I keep talking about. And I'll see you next time at the next video. Take care, everybody.